At some point, we've relied on tools and we haven't questioned that. I don't know how my cell phone actually works. And But now we've been introduced to this AI, and I think people are freaking out a little too much.
AI has arrived in today's courtrooms, but will it have an impact on the justice system's core principles of fairness and accuracy? Welcome to Clarity on Tech, a podcast powered by the Thomson Reuters Institute. I'm Zach Warren, the Institute's Technology and Innovation Insights Lead. In each episode, we dive deep into the future of the legal, corporate, tax accounting and audit, and government communities. Today, we explore the intersection of AI efficiency with fairness and accuracy. Court rules have been grappling with exploding data volumes for years, but today, AI technologies bring a new element to the conversation. To dive in, here's TRI's Rabia Butler to introduce Judge Maritza Braswell and Judge Xavier Rodriguez, who will explore how they view key rules of civil procedure and evidence in an AI world.
Artificial intelligence isn't just knocking down the door at the courthouse, it's already inside. It's reshaping how we approach discovery, it's elevating how we evaluate evidence, and it's going into how we conduct litigation. But with this technological revolution comes a host of complex questions that demand careful consideration from our judicial leaders. Today, we're privileged to hear from the desks of Judge Maritza Braswell and Judge Xavier Rodriguez. They grapple with these issues every day. While they can't speak for the entire judiciary, they will offer practical courtroom experience and thoughtful analysis of one of the most pressing issues facing our legal system today. As AI tools promise to transform how we handle the ever growing mountains of electronic data in modern litigation, we find ourselves at a critical crossroads. We question, can we harness AI's efficiency without sacrificing our accuracy? Are we so focused on perfection that we are missing opportunities for meaningful progress? And most importantly, how do we navigate the legitimate concerns about AI and how we can embrace potential concerns to serve justice more effectively? From document review to evidentiary standards, from discovery protocols to courtroom procedures, AI is raising questions that didn't exist a few years ago. Join us and our judges as we share insights for experiences and visions for how legal profession can thoughtfully integrate artificial intelligence while upholding fundamental principles of fairness, accuracy that defined our judicial system. This is more than a discussion about technology. It's a conversation about the future of the law itself. Welcome, Judge Braswell and Judge Rodriguez.
Thank you.
Thank you.
Good to be here.
Yeah, I'm excited for this conversation. I find it energizing, I think, to be able to have a conversation with someone else who's thinking about these issues a lot. These issues are sort of top of mind for you, I know, as they are for me. And we're busy, obviously, with our day jobs, but it's such a pressing issue. I think both you and I recognize that we need to be thinking critically about it. So I'm just going to launch in so that we use this time wisely, and thought I would set the table to talk about the topic today by first raising Rule 1. Federal Rules of Civil Procedure, the first rule, basically imposes on judges as well as parties a duty to be efficient, right? To apply the rules in a way that's going to ensure not just a just outcome, but also an efficient one and a speedy one, and that sort of in the face of all of this work that we have to do when we work through things like discovery can sometimes be tough. And in the context of what we're talking about today, my first question is, does technology make it harder or easier to fulfill that duty? Is technology a good thing or a bad thing when it comes to the efficiencies and speediness with which we want to resolve cases?
Yeah. So it's a cutting edge sword. At one point, technology has just now caused a proliferation of data. Data not only has expanded in the amount of data from, I mean, a big case used to be bankers' boxes, and we had documents and paper, and we would make photocopies, bait stamp, and we thought that was all big. And now data has just proliferated, and what technology has done, though, more than just expanding the amount of data. Data is now everywhere. And so, for the most part, when I was starting off as a baby lawyer, I mean, data was in filing cabinets or in banker boxes, and the client knew where we had to pull those documents from. But now, fast forward to today, and documents are in local servers, uh, email servers. They may be redundant data located in cell phones and mobile devices. And then we got cloud data storage. And then we got the collaborative platforms that have now started emerging, Slack, Teams. It's just from that standpoint, technology has been, I guess you could say, a curse. But it can be a blessing too, right? Uh, One of my friends, Craig Ball, who's real prominent in e-discovery circles, poses the question this way: why are we complaining about all this data? In this day and age now, data and all these sources of data have us now with an opportunity to learn the truth through GPS or through metadata stored in a phone. We now know exactly where a picture may have been taken. We have metadata that expose time frames. We can create a chronology of events and better understand what exactly happened. So we actually have now, because of technology, an opportunity to find out the truth. And so, to that extent, data's and the proliferation of data has been good.
Yeah, yeah, that makes sense. Well, let's fast forward a little bit now to AI in its current form, because I think you sort of described an evolution, right? You start with kind of the banker's box scenario, and to your point, clients knew where those banker's boxes were and could explain, this is the room that I pulled it from, and this is why it was stored there, etc. And then also to some extent, clients can explain, or a party can explain the source of particular metadata, or the GPS issues now are sort of, we've wrapped our heads around that enough to be able to explain it. But now we're in a new age, right? And oftentimes you hear about this concept of the black box when it comes to AI, and these systems being so powerful and so capable, and in many ways so complicated that it's harder to explain. It's not like the banker's box that you can say, this is where I got it from, or the metadata that we've now gotten used to sort of hearing about and how it was pulled and the experts that did the work on it. It's looking different. So I guess the question is, how important is explainability now? Is it more important? Is it just as important as it always was, but maybe just a little bit more difficult? Or is it just different? Is it a different animal because of the type of technology that we're dealing with now?
Yeah, so it depends. The usual lawyer answer, right? It depends, right? What are we using AI to do? What if it's just summarizing documents for us? Do we need transparency necessarily for that? If it's creating a timeline for us, transparency doesn't need really to be all that concerning there. If we're using an AI algorithm, though, to uh, uh, or to be either an assistive device or actually the decision maker for sentencing, well, then transparency gets a lot more concerning for those kind of things. So I think we got to step back. We're always worried about transparency and bias, and those are valid concerns. But it all depends on what we're using the AI for. If something like that is going to be problematic, like on bias, if we're just using it to summarize documents and the AI algorithm comes up and says he too many times, well, that's easily editable by, you know, someone reviewing it and putting the proper pronoun. And so, the bias of the data being skewed masculine is really not all that of concern. Again, if we're talking sentencing or bail decisions, well, then now we're worried about, well, how was the tool trained, and has bias seeped in such that we're getting uh, outcomes that are discriminatory. So it depends.
Yeah. When we were preparing for this conversation, that was actually my favorite part of the discussion that you and I were having, and the view that I thought I heard you put on the table, which is consistent with what you're saying now, and that is, let's be concerned about overkill, right? Let's not let the perfect be the enemy of the good. Yes, it's important to talk about responsible use. And it's important to talk about things like transparency and bias. No doubt, those are critical issues we have to be very vigilant of. But at the same time, we can't sort of get in our own way and we can't overdo it to the point that we are making the standard sort of impossible, which kind of brings us back to rule one, right? Do you think there's a risk in the age of AI of overkill, right? Of worrying so much about these issues that we create these realistic standards and make litigation so costly and complicated that we're actually running afoul of rule one.
So like, just like think about it. That's an employment discrimination case, right? And all of a sudden, we're doing a calculation of lost wages, and somebody put it all into an Excel spreadsheet. I mean, honestly, am I asking for transparency? How did that Excel spreadsheet, reach this decision, and how can we be guaranteed that this formula, when I said add or sum, is actually producing the correct? I mean, at some point, we've relied on tools and we haven't questioned that. I don't know how my cell phone actually works. And But now we've been introduced this AI, and I think people are freaking out a little too much.
Do you think it's because the technology fundamentally different and sort of eerily similar to the way humans interact with humans, and it catches us sort of maybe not quite off guard. I mean, now we've been hearing about it a lot, but it definitely gives us just a deeper sense of mistrust because of just the way the technology works. Do you think that has something to do with it?
That's part of it. I think it goes even deeper, though. I think we're fundamentally afraid of what's going to happen in the future. And now, I don't want anybody to misunderstand me. I'm afraid of some aspects of AI. When I hear that even our Air Force now has militarized some jets with AI technology, so that the jets were being driven by AI, well, then you naturally start wondering, well, who's going to drop the bombs, and is that a human decision or what? And then you start going from there, right? Well, I mean, the Pope is even concerned about AI, right? Is this going to displace humanity, and what jobs are we all going to have? And I think we've taken those kind of big picture concerns, and now we've started embedding them on, well, what's going on here. And I really think we need to break these things apart. What use is this AI going to be inputted in? And so, if it's like militarization, well, then we need to be very concerned, and there ought to be a different kind of policy analysis about whether or not this is a good decision or not a good decision. But as we go down the food chain for different uses, we can't come up with that same mindset of this is uh, potentially human life ending when we're talking about whether or not we should be using it for summarizing a deposition. These are two different uses that we shouldn't be applying the same concern.
Yeah, that's a great. And I'm share that perspective that there are some big ticket societal risks associated with this technology, right? Misuse, misalignment, big disruption to societal structures potentially, but that doesn't necessarily change that in our profession and in many professions and really across society generally there could be incredible benefit to it, while still sort of mindful of the risks. We need to figure out how to leverage and use this technology. In fact,
The medical industry is doing the
oh,
medical profession is doing a job. I think we in the legal profession we should start looking and trying to emulate, right? How risky is this stuff, right? We're using AI to make some assisting in medical decisions. That's very problematic when you think about it. But at the same time, we're now finding that like AI assisted tools can now detect uh, very early forms of cancer better than radiologists can. It just we ought to be doing exactly what the medical profession is doing, figuring out where we can implement AI responsibly, safely, and for us, in our case, reach a product that will assist our clients, or in the case of us as judges, assist the judicial process.
Yeah, I'm glad you raised the medical analogy because I like that analogy a lot for this point, which is at what point, or this question, I guess, at what point do we have a responsibility to use the tools? So, not a responsibility to stay away from them, but a responsibility to use them. So, in the medical profession, at what point is an AI system or program going to be much better at intervening or detecting something or potentially, identifying life-saving issues, and the medical professional has some responsibility, moral or otherwise, to actually use these tools. And similarly, we have a huge access to justice problem, right? And at what point is there going to be some duty on our part as a profession to really look at these tools and say, can they help us solve this access to justice problem? We're not throwing a bunch of judges at the system anytime soon. Maybe there's a way to leverage these tools to help close that gap.
Yeah, we're never going to throw enough lawyers and judges to beat this problem, and so it's going to have to be for legal service providers, pro bono lawyers. We're going to have to implement some AI assisted technology to help expand the reach.
Yeah, I agree. Well, going back to sort of what's happening with the maybe over concern, I guess it's not a word, right? But I'm going to use that word, over concern around the issues and sort of hesitancy to leverage these tools, and maybe overcomplicating things. Are you seeing some of that in, for example, ESI protocols, or do you, if you haven't seen it yet, because I think some of these things are sort of on the horizon, even if not right in front of us yet, do you anticipate that things like ESI protocols are going to be so complicated that they're just not worth implementing because it's going to, people are trying to anticipate every possible thing that could go wrong with these systems and trying to shoehorn it into a protocol to address the issue that happens.
Yeah, so I'm not a big fan already of ESI protocols, and much less now fighting over AI implementation in discovery, and now expanding the fight for ESI protocols. Somehow or another, and let's backtrack for listeners who may not be uh, uh, on board with us here. So, in the discovery process, oftentimes, generally in big cases, but not always, but in some big cases, the parties will have their lawyers uh, start contemplating things like search terms or custodians or the form of production. How should it be produced in PDF, in native, and so. Uh, I'm not against lawyers cooperating with each other about how discovery should be done. That's a good thing, and I don't have a problem with lawyers reaching these agreements if it's just them having an agreement amongst themselves about how things should be done. But the where it gets problematic is oftentimes these ESI protocols get presented to a judge in the form of a order that the judge signs. And now
Mhm.
we have a binding order on the parties about how discoveries to be contemplated.
Right.
The problem with it is what I see and what I see in the case law is that the parties take forever to reach these agreements uh, at great cost, and I'm not sure what bang for the buck they necessarily get for all those lawyer fees being expended. Number two is you oftentimes have a judge, specifically a magistrate judge, getting caught into the fray. Judge, well, we've agreed to 80% of these agreements, but we're fighting over these 20%. And we want you to make rulings on how this production should go.
Right.
Procedurally, I think we got it all wrong. The rules contemplate that a requesting party requests documents, a producing party produces those responsive, relevant, privileged or non-privileged documents, and then once a showing has been made by the requesting party that there's been a deficiency in the production, then they can file a motion to compel. But now we've taken that paradigm and completely moved it to the front end, asking magistrate judges to be making advisory rulings before we ever even have a problem with the actual production. Uh,
Mm.
I think we have a little problem there. The bigger problem is these parties have been fighting back and forth over these ESI protocols, and oftentimes they haven't tested those protocols to see, if it's keywords, are they under inclusive, over inclusive, are they going to come up with too many hits, are they going to come up with too few hits, and no one's tested this stuff, and they enter this order, the judge enters this order, and then production's made, and then everybody, one or both sides, wants to redo the order because they find out it's deficient. Uh,
Right.
and now we're going to introduce AI to that already existing problem. It's only going to get worse.
Well, do you think it'll get worse, or do you think there's a chance that it could help in some respect? And I think about it this way. I mean, AI is really this predictive system, right? That's kind of the underlying technology, is being able to take a lot of data and then make predictions about what comes next. And I wonder if that technology is going to be useful in giving lawyers sort of a window into what this particular protocol that you're negotiating is likely to lead to or not likely to lead to, and then better be able to negotiate the protocols on the front end. In other words, not necessarily change the order of things, but maybe just make it work a little better in the age of AI. Do you think that's possible?
That may be possible. Where I would prefer to see us go with AI and e-discovery products put out by the various vendors is I want AI e-discovery tools to help us get early case assessment. And so we each side asks their own AI e-discovery tool to find us, the relevant documents regarding issue X, issue Y, issue Z, uh, and we use the AI tool to push up documents. This is not full scale discovery. This is not in response to requests for productions or anything like that. This is an early case assessment. Both sides push up the hot docs if they're going to be relevant and if they're going to be discoverable. Everybody shares the relevant non-privileged hot docs, and you know we all know most cases settle, right?
Yeah.
And so let's start looking at both sides hot docs early and figure out, do we have to go through the most expensive phase of litigation, the discovery process, when we realize these are going to be the hot docs that are eventually going to come out. Now,
Yeah.
I can talk on the other side of my mouth on this because the concern is we're always afraid of, well, I'm going to be righteous. I'm going to produce all the relevant documents that I have to produce, but I know the other side's not. And that's going to be the burden we have. So if someone's actually come up with an idea. I haven't read their whole uh, article. It just came out today. Uh, uh, but there was a symposium earlier uh, on an MDL conference, and it was advocating for this, that we let the concept of discovery be so broad and the concept of relevance be so broad that we go through all this expense. Why don't we both get one AI tool that both sides ask for the hot docs, and the AI tool produces the hot docs, and both sides get the hot docs, and maybe that would confine more relevance and lead to more early case assessment.
Yeah.
It's an interesting thought.
You know what I like about that, and to your point, I can see pros and cons, right? There's probably all kinds of ways to think about it, but this is what I really like about that idea. It's working outside sort of the current system. It's innovating outside of the current constraints. I think what's happening a lot these days is we're talking about AI and whether or not it can be grafted onto existing processes to sort of tweak them. As I was kind of talking about earlier, could it make the current process of protocols better by predicting what might happen later? That's an example of sort of grafting it onto our current processes, our current workflows, our current way of managing cases, I think it's really important that we start thinking outside the box, because these tools are going to make new things possible. And the old way of doing things may not be the best way of doing things anymore. So we have to start thinking, okay, this isn't what we do right now, but these tools may make it possible to do some early case assessment, or to think about the beginnings of a case completely differently than we think about it right now, which is, pretty defensively. So I like that idea for that reason. It's thinking outside the box. I think we need more of that, right?
Yeah, uh, we've at least in the federal system, we're relying on rules that have a genesis in 1938, and we keep putting rubber bands here trying to make it all work. And maybe we need a new rules. Talking about initial disclosures. Arizona tried that in the state court system out there. They had mandatory disclosures, and the bar didn't like it. They tried it also in Illinois, and the bar didn't like it there either. Uh, and they at least in Illinois, it was a trial period, and in one of the, I can't remember which federal district court, and they ended the trial. They got so much backlash from lawyers. Uh, Not only do we have to change the rules, we have to change our mindset as lawyers. Uh,
Right.
so many of the lawyers think, okay, well, we don't do anything until we get served with a request for production, and it's like we've been trying to tweak these rules, like the initial scheduling conference, the Rule 16 conference in federal court, where you appear for the first time in front of your judge. They tried to make this rule an opportunity for a dialogue between the lawyers and the court as to what the appropriate scope of discovery should be. Uh, but applying the existing mindset, lawyers haven't done any real substantive work on the case, so they can't answer any questions. We can't have this dialogue. Uh, all that has to frankly change.
Yeah. Yeah. Those are good points. I love that point you just made, which is it's not just about the rules, it's also about our mindset. Let me shift to something else that I think concerns the mindset, at least of judges right now, and that's as it relates to evidence. We keep hearing about deep fakes. We keep hearing about how great these tools are, how capable they are nowadays in terms of generating videos and images and documents. And I think many of us are sort of sensitive to that, and thoughtful about the fact that any day we might get presented with some piece of evidence that could get challenged or maybe not challenged, right? And the scary part is it just sort of slips by us. um, how are you thinking about that? I've heard some judges, I've heard a couple of webinars talking about sort of frameworks for being able to kind of sniff out when we need to do a little deeper of a dive into a piece of evidence presented before us. Do you have a way you think about those things? And now that's sort of out in the world, is there an approach you take?
Yeah. So, I studied history in college, and I've just never left studying history. And so, when we start talking about deep fakes and everything else, one of my slides that I do in the demonstrations I give, uh, it's a part of an Egyptian obelisk. Uh, And so what it shows is one pharaoh carved out the name of an old pharaoh. We have been doing manipulation of evidence forever, right? So going back to the times of the pharaohs. Another great picture I put up on this PowerPoint is a picture of Stalin. He's walking with two fellows around. I think it's a sign, but maybe it's another river, and then one of Stalin's purges takes place, and now he's only walking with one other person, and the other person was just completely excised out of the photo, probably got killed. And so we've been manipulating evidence for a long, long time, and now what makes this new is uh, we had the ability in these other examples I gave to find the, oh well, this was actually altered. Now with deepfakes, the ability to differentiate what's real and what's not is getting very blurry, if not almost impossible to differentiate. I've created a deepfake on myself. There's a AI tool. I teach on the side, and one of my classes is completely online. And I thought, let me create an avatar myself, and it'll be used for my teaching. Uh, so what's so scary about this? Now I had to pay $200, I think it was, for this tool.
Mhm.
Uh, More than my cheap self wants to pay. But I spent $200. Is because of the number of minutes. For a lecture of an hour, I needed that kind of an access. But all it took was for me to upload 3 photos of myself. I talked into the program for maybe 4 minutes, reading off text that was coming off the screen, and then within about 4 or 5 minutes, this AI tool created an image of me speaking. And one of my daughters, I've got daughters on both sides of the coast, called when I was playing the feedback of this tape. And one of my daughters actually said, "Dad, are you recording something?" And it's like she thought it was me.
Hmm.
It was the avatar. I mean, the audio is that good. The audio is dead on. Now, the video was still slightly off. For some reason, it took a few pounds off me. That was nice. But the video was off. But had I uploaded a lot more screen or images, or better yet, video, it would have produced a much more accurate image of me.
Hmm.
And so, what's so scary about this? I am really nervous for family law judges in the various states.
Hmm.
Uh, you're going to have some disgruntled spouse all of a sudden surreptitiously record their other, uh, create one of these fake things that I did within a matter of minutes. You can do it for $20 on this platform. It'll only give you like 3 minutes of a product or output, but that's all you need if you're going to go up to some judge on a state matter, ask for a temporary restraining order to take someone's kid, or get a restraining order because of alleged violence. You can now just type in the violent response that you think you want to type in. The avatar will speak it, and who's going to tell what's real and not real? It's getting concerning.
Yeah, yeah, and I think the big difference, you were alluding to this earlier, it used to be that perhaps evidence is manipulated or altered. Now it's like wholesale creation. And to your point, you can really have this video or this image say or do or be really whatever you want. And the second thing that's, I think, quite different now is the level of accessibility, right? To your point, these tools aren't that expensive. Anyone can access them. We're hearing about them all the time. You don't have to be some Photoshop expert or computer whiz to be able to make this happen. So I do think it's a different time, and it's something that we're all mindful of. Going back to the point of, what standards do we apply in this world that's increasingly looking different? If we are sensitive to this, do we run the risk of maybe imposing too much of a burden on lawyers in terms of proving things, or being too suspect, right? And then having every case cost more and take more time because we feel like we need to diligence everything to the nth degree. Is that a risk to be mindful of as well, sort of countering the fear that we all have in the back of our minds?
Yeah, it is. It for a couple of reasons. What I'm concerned, I fully understand where people who want to up the admissibility burdens are coming from. I fully get where they're coming from. They're concerned about these fakes, and we're going to have a lot more demonstration about the authenticity of the evidence that's going to be shown to the jury. Very good studies are being shown about juries, once they're exposed to this, have a hard time mentally uh,
Right.
getting that uh, image out of their mind. And so I understand fully where they're coming from. But I am concerned about this. One's going to be the cost factor, right? So in the big case, I could see us all hiring our AI experts to somehow come up with an explanation about why uh, the AI evidence is either true or not true, and if it's AI created, how it's reliable. Uh, and so in the big cases, I guess we're going to expert up. I'm not sure who's going to be the experts in all this. That's a question. Uh, how much that's all going to cost us is another big question. Uh, but I'm a little concerned about the next step. Uh, so generally, for traditional evidence, photographs and audios, uh, we have generally had a low threshold for evidence, and all you had to do was put somebody in the witness stand saying, "Here's this audio recording. Is that X Rod? Yeah, it is. I've heard him plenty of times. Um, Sounds just like him. I know that to be accurate." Or this photo. Yeah, I know this scene. I've been there past this place plenty of times. That's a true and accurate image of that house. Uh, and so it's been basically very easy to get evidence in. And now, but that evidence is up for the jury to then give it whatever weight it believes it's entitled to. And they could find that the other side's arguing it's not really that audio or it's not really that house photo. And if they're prone to believe it's not, then they can disregard the evidence. With what we're doing now with some of these proposals about having a higher burden for AI generated evidence, well, at what point are we going to take the jury completely out of the decision making process here? Uh, are they no longer going to be finders of the fact? Are we as judicial officers going to be the ultimate gatekeepers of evidence coming in? Uh, and what is going to be the role for the jurors now in light of this new AI world?
Mm.
And so I'm thinking we're usurping the role of the jury in part for all this. I understand where people are coming from, but I have that little nagging part of me saying, "Well, that's for the jury to decide." Um,
Mm.
we are.
In- Interesting, and perhaps like so many things, it there isn't one sort of clear answer for every case. It sometimes depends, right, on the facts and circumstances, the individual piece of evidence, and so it's never quite that easy. And I feel like we're often really in this window of time where we just have to be asking the right questions, even if we don't necessarily have all the answers right away.
Right. Absolutely. No, I agree with that. So, as lawyers and judges, so, if your client walks in with, "Oh, here is the absolute evidence of him threatening to beat me," and that sounds too good to be true, it probably is, right? And so you ought to be asking questions of your lawyer, of your client. Oh, well, how was this audio captured? Uh, oh, it was on your phone. So let me see your phone. And then we're going to try to find out where on the phone it was, right? And we can use still in this age of AI, we can use still some old school techniques, right? We can look for the artifacts, we can look for the metadata, and so we want to be asking questions like that as lawyers, and then same thing as judges. In the hypo I gave you about someone coming in ex parte for a temporary restraining order on a domestic violence case, even that judge ought to be asking, okay, how was this taken? Where did you get this audio? And so we ought to be asking at least some baseline questions. We may not need yet the whole AI experts to come in here if some of these initial questions can't be answered. They can't tell you what device was used, or now this device all of a sudden somehow made it to the bottom of the lake, but we have another copy here. I mean, at that point, some of this other stuff does lend to err on the side of the critics of AI to say this is now looking unreliable.
Mm.
Uh,
Yeah, and these may not need to be fancy frameworks involving experts all the time. It could be, judges using basic tools, some basic common sense. What you just described is similar to something that Maura Grossman, who's the one of the co-chairs for the working group that's focused on AI issues, the Sedona conference. She put together a webinar. She was part of a webinar where she was introducing. Uh, the judicial bench cards that Thomson Reuters and the National Center for State Courts partnered on, that kind of give judges a framework for how do you deal with AI generated evidence? How do you deal with what they call unacknowledged AI, which is no one's talking about it, but it's AI generated, or acknowledged AI, which is they've admitted it's AI generated and you still have to apply a slightly different standard. And the way she laid out this framework for how do you even know to look for it when we're talking about unacknowledged AI was, is it too good to be true? Is the source now missing or somehow unavailable, and is the reason for why it's missing or unavailable kind of complicated and difficult to follow? And those are sort of basic questions you can ask yourself, and I think judges, we do ask ourselves those types of common sense, simple, straightforward questions. So a lot of that still works in this world, and we don't need to quickly jump to some very complicated framework. um, and speaking of simple frameworks, I really appreciated I think it's an 8-page guideline that the Sedona conference put out that I know you worked on. You were part of the group that developed that. And it's high level enough that let me start with, it's specific enough that there's clear, practical guidance in there. It's also high level enough that we can kind of make it our own when we're thinking about our own use cases. Was that intentional? Did you all intend for it to be kind of, room for folks to explore, for judges to explore different use cases when it comes to AI?
Yeah. So we amongst ourselves we're exploring about just how comfortable we were in producing this guidance, and it's safe to say there was a spectrum. There were some people on that uh, working group that really thought this was premature. AI was not ready for prime time, and we should be advising that way. And it's safe to say that I was probably at the other end of the spectrum, saying, "Hey, this is pretty cool. I've been playing with it, and I see a lot of value." And then the others were sort of in between. So it was a give and take about just this guidance and what advice we ought to be giving out. And so we reached a consensus document. I think it's a pretty good consensus document. We give a list of things you may want to consider as a judge, and frankly, it applies, I think, to lawyers too. Uh, and But overarching on this, as for judges, I think we were all insistent, and me included, that we should never relegate our judicial decision making to an AI tool. That there's always a judge at the helm making the final decisions, and that AI is a tool to assist us in chambers to get to that ultimate uh, judicial decision.
Yeah. One of the things that in my mind that guide does, beyond giving, the practical considerations, I think it also opened up conversation, which I think is really important. There's a bit of a chilling effect, I think, from some of, we've seen standing orders from judges that say don't use it at all, which I understand why. I mean, it's there's a lot to grapple with there, so I'm certainly not um, suggesting that they shouldn't do that. But it does create a chilling effect in terms of having open conversations about it. There, obviously is a huge spotlight on the hallucinated cases and the briefs. And so that chilling effect is causing people to shrink. I think that's going away a little bit, but it's guidance like this, put out officially under the Sedona Conference journal, that helps people just be more open about it and have important conversations. So I think there's value just in that piece of it.
Yeah. So on that last point, at least my takeaway from all this whole conversation is, I think AI is it's definitely not going away. Our clients and the litigants are going to be using AI tools. It's going to come up in evidentiary issues. So judges, we can't hide. We can't say we're not going to deal with this. You can't use this. That's all just impractical. And so. Uh, there's a spectrum you can go to, and there's three judges across the world who have already used AI as a final determinative tool to issue an opinion. I don't believe AI is there yet. It may not get there, but it may, but we're not there yet. So AI is a tool in the judge's chest, here to pull out and use as our workloads never cease and only continue to grow. There's a I would encourage everybody to look at that Sedona paper that we referenced. We give you a lot of practical tips about what are we think safe uses. I think that would be beneficial to you in expediting your work and actually having a better conversation with the lawyers in hearings. It'll help you in prepping for hearings. Uh, I use AI tools, frankly, to prepare chronology of events because I'm very chronology oriented. And I also use it to give me ideas about what questions I might want to ask the litigants in tiering discovery. And so, a lot of beneficial uses. Don't let a lot of the AI, it's going to kill us all, talk, uh, you know, dissuade you from a careful adoption. Uh, the early users are going to be the ones who are going to benefit most. Uh, Lawyers, this is passe. Everybody's been saying it. Lawyers who don't use AI are going to be replaced by lawyers who do. I don't think it's going to replace judges, but uh, we're being required as judicial officers to do more with less every year, year upon year. And so we're going to have to augment our chambers.
Yeah. My thoughts are very similar to yours, which is it's here and we can't ignore that it's here. We have to be very thoughtful about it. I think conversations like this matter, both because we're having the conversations and then having the conversation that stems from this with others, but also because people then get to hear this conversation and say, okay, I'm going to be open about this conversation as well, and I'm going to be open about my use cases. And through that discussion, I think we become more responsible users. We become more innovative, which, as we talked about earlier in the conversation, is important. We have to think outside the box. We can't just graft this technology onto our current systems and workflows. We have to be thoughtful about how workflows can change entirely to promote justice, right? We have a real access to justice problem, and we may soon have a duty to start looking at these tools. But why not be an early adopter that's looking at them sooner rather than later? So, very similar thoughts. Thank you so much for having this conversation with me. It's been awesome.
Oh, likewise, I've had a lot of fun. Thank you.
Well, thank you both for your time, and I think you've encouraged us to go uh, from working about perfection to focusing on progress. And I think we've had a great conversation. Thank you both.
I'd like to thank Judge Braswell, Judge Rodriguez, and Rabia for taking the time to speak with us today. As the judges note, AI is rife with possibilities, but also concerns. Just because AI makes FRCP Rule 1 or the Federal Rules of Evidence more complex does not mean that those rules can be ignored. Indeed, the conversation is just beginning, and it will take input from the bench, the bar, and all in the legal community to chart a new path forward. Thank you as always for joining us for Clarity on Tech, powered by the Thomson Reuters Institute. You can follow or subscribe to this podcast on your favorite podcast platform, and don't forget to share with your colleagues and leave a 5-star review. For more data-driven analysis of today's professional services market and in-depth conversations with industry thought leaders, visit us online at thomsonreuters.com/institute and follow us on LinkedIn under the Thomson Reuters Institute. Clarity on Tech is a production of Thomson Reuters, copyright Thomson Reuters 2025.